So the Supreme Court case in question, Kennedy versus Bremerton Area School District, it's a simulation that I run with my AP government class, in which they're able to work their way through the Supreme Court proceedings, giving them a opportunity to visualize how the court works on a personal level. So instead of just learning about it in the books, we run through the trial, we prepare. Each of the students are given a specific job, whether they're a judge, they are one of the lawyers representing either of the two parties in the case. And it gives students an opportunity to be able to work through how the process of researching a case goes, looking at past precedent, examining the Constitution, and then trying to ultimately make a decision by the court that would represent how the court would actually rule in the real world. So it's a great opportunity for students to be able to, in a tangible way, make sense of the day-to-day operations of the Supreme Court of the United States.
Just hit the timer. It's set for 10 minutes. Each side will have 10 minutes to present their case. Hit it when we're ready to start. I just want to make sure everyone's got everything that they need. Is everyone ready? All right. So, one last note, just for those who are visiting, the Supreme Court lets the person who's petitioning the court first go first, and then they have the people who are in defense, or excuse me, opposition to the petitioners. They always go second. Now, typically, you guys at the end of what they say would be able in the Supreme Court to have a rebuttal, but for today's sake of time, you don't have that. So you got to make your case in one shot.
It was what was the name of the case? It was Kennedy versus Bremerton Area School District. So it's based off of a real case that actually happened in Washington State that had to do with students prayer in school. And in this particular case, it was a football coach who was praying after football games, and it was challenged by the school district whether he had that right or not. And so my goal was to see if my students could come to the same conclusion that the court made.
Our client, Mr. Joseph Bentley, under the Free Exercise Clause in the First Amendment, has the right to practice his religion in public spaces. This applies to the schools because they are state-funded, and with the Due Process Clause in the 14th Amendment. All rules from the amendments also apply to the states. When the client initially practiced his religion, adding religion subtext to his pre-game speeches, he stopped after warning. However, when he prayed on the field after, he never coerced his athletes to participate, meaning he never violated the athletes' religious rights.
He gave a religious speech to his players after games. He did this regularly after games. He was warned by the school district that he was violating the Establishment Clause under the First Amendment. He began to quietly pray to himself, but still students would join him. The school district had rightfully put him on administrative leave. This is a violation of the Establishment Clause, as a school district cannot act in favor that promotes a religion or any religion. The Establishment Clause states, Congress shall make no law respecting an establishment of religion. Favoring one religion over another, or favoring religion over non-religion, his purpose is to ensure separation of church and state, fostering religious freedom and neutrality. Government employees such as teachers and coaches cannot promote or endorse religion when acting in their official capacity at a public school.
In a precedent, Garcetti versus Savalas from 2006, the court said the school, an entity of the state, is allowed to control what a coach, a representative of the state, can say while he is working. Mr. Bentley is standing on the state's 50-yard line in his state-provided uniform. Isn't he still on the clock? Why shouldn't the school be able to tell him to stop?
Like we mentioned earlier in the schoolhouse key principle, workers are their speech and religion is protected through the court case 251 versus 51, which has not been overturned. So it would create a conflict.
You can follow up to any question if you want.
I don't really have a follow-up.
Okay. We're good.
Okay, I have a question for them as well. So the Establishment Clause of the First Amendment, it prohibits the government from favoring one religion over another. Bentley's prior does in fact favor one religion. So considering Bentley is an employee of the state, therefore the government, why does this clause not apply to him?
In the first instance, when he was putting his speech into, or his religion into the speeches to the students, that would apply. However, in the second case, when he's praying privately, he's no longer out spreading it. It's to himself. There's not anything that he's forcing onto the students or to anyone around him. It's pretty private.
Privately in the middle of the football field?
It's not like he's talking out loud to the point where it would be considered.
In the case of Bentley versus Berkeley Area School District, Supreme Court of the United States, in a unanimous decision, rules in favor of the Berkeley Area School District. The High Court thanks you for your time and effort.
Okay, here we go.
Well, thank you, guys.
Excellent, folks. Good job. So, how many people actually found the real case this is based off of? Anyone? That's why I told you. That's why I told you nothing before or nothing after 2015. So, what was the case?
Kennedy versus Bremerton.
Kennedy versus Bremerton Area School District. And how did it actually end?
5-4.
Kennedy. So it was actually their decision was reversed the decision that was made today. So they decided they ruled in favor with Coach Kennedy. So excellent job, first of all. So you had really good questions. The precedents were amazing. You dug deep in the cases I don't even know. So I wrote them down, but I'll have to go back and research them, make sure you use them in the right context. But they sounded legit. So any questions? Okay, so
My goal was to see if my students could come to the same conclusion that the court made. And ultimately they did not, but that's okay. It was a split decision when the Supreme Court made their decision, and so I would expect that students might take one side or the other.
What was the original decision?
Well, the original decision was in favor of Coach Kennedy, saying that he did have a right to be able to pray after a football game. So I believe the decision was a 5-4 decision, if I remember correctly, or a 6-3 decision. So, does that make sense? Mm-hmm. All right. Any other questions?
No, off the top of my head.
All right. Very good. Thank you so much.
Yep.
Okay.
Welcome. Today we're interviewing a defense attorney, but it was a very good mock trial case based off of a coach who wanted to pray in front of his students after a football game, right? And they were disputing the constitutionality. Now, Chase, tell me, what role did you play in this case?
I was the plaintiff. I was for the school. That's what I did.
Okay, now what kind of defenses did you make, and what did you think of the case?
I thought the case was very good. It was definitely exciting. There's some nerves going into it. I mean, you're going into it thinking like you obviously want to win the case. But obviously we pulled through and won because our claims were amazing. But other than that, no, it was great. It was great. It was a fun experience.
Great answer. Thank you. Now, you saw the original case from the Supreme Court. Did you agree with their original ruling, or did you disagree?
In the original court case, the coach ended up winning and not the school. In our mock trial, we won as a school. But I agree with the original court decision. In the original court decision, they had very good. The defense attorney had very good claims and very good actions. So I 100% agree with the Supreme Court's decision in the original trial.
All right, thank you so much. That's the plaintiff point of view. Moving on from the plaintiff, today we got I
was a defense attorney for Berkeley School District, and my name is Ori Godown.
Now tell me, Mr. Defense Attorney Ori Godown, what do you think about this Supreme Court case?
Honestly, I thought it was pretty interesting because, like, First Amendment freedom of speech rights, it can get really touchy, and not everyone's 100% sure, like, what exactly the line is for, like, expressing your religion, like, throughout the case. So I was pretty nervous going into it just because it's a pretty touchy subject.
I understand. I wholeheartedly understand. Now, what decision did you make? Like, what kind of defenses were you making for the school?
So for the school, we made that since the coach was in uniform at like a school-sponsored event, we said that he wasn't allowed to promote the religion because schools aren't allowed to promote religion because they're related to state, and state isn't allowed to promote any religion at all, or no religion. They have to be like equal. And since he was praying, it seemed like he was promoting a certain religion.
Good answer, good answer. Now, since you as the school ended up winning this case, how do you feel about the original Supreme Court case where they voted in favor of the man, the coach?
I think that they were wrong and that the school was right, but since the Supreme Court is mostly like Republican conservative, they value a lot of religion in like state, like intertwined more. You know what I mean?
Yeah, for sure.
But I honestly think that the coach should not be allowed to pray because he is promoting a certain religion, and it looks like to anyone watching the football game, it looks like this school is promoting said religion.
I wholeheartedly understand that. Thank you so much for your time. Thank you. All right, there we go. Moving on from both the plaintiff and the defense attorney, today we got Lainey Snyder, who was...
I was a judge.
All right, now Lainey, tell me, how'd you feel about this Supreme Court case?
I think it's really important. I think religion in schools is a really touchy subject, and I think it was like really valid to be in the Supreme Court.
Okay, that's fair. That's fair. Now, as a judge, what influenced your vote? What was your thought process going in there? What decision did you make?
I think the thing that like was the most important to me was like the publicness of the coach's prayer. I think if he would have kept it more private, like that's different, but that's what mostly impacted my...
Okay, that's definitely fair. So now the original Supreme Court case voted in favor of the man. They voted in favor of the man who was praying, defending his right to freedom of expression. How do you feel about that? Do you agree or disagree, and why?
I disagreed. I think, once again, that it was really public. If he would have kept it more private, that's different, but it was public. They told him to stop, and he almost made it more public by going to the middle of the football fields. I guess the prayer was to himself, but, I mean, it's in front of hundreds of people, so, yeah.
That's definitely fair. Thank you so much for your time. You heard it right from the judge.